inquiry into the Hazelwood mine fire is now in session.
If the board pleases, we'd reached a point before the luncheon adjournment where I think I'd got to paragraph 43 of the findings in our outline in respect of the fourth topic, and I've been considering the regulatory structure in Victoria in relation to mines and health and safety, and then I had discussed the issue of compliance GDF sewers with the regulations and implementation by it of recommendations from previous fires. If I could turn then to the issue of fire mitigation practices by GDF sewers itself, which is a matter raised for the inquiry by the second of its terms of reference. Although there's been a good deal of concentration on the regulatory structure and the implementation of the regulatory structure by the regulators, it is important to bear in mind Professor Cliff's observation from his report that a focus on any failures of regulation should not obscure that the primary responsibility for the management of risk rests with GDF sewers and not the inspectorate. The evidence before the inquiry is that a work plan for the Hazelwood mine was approved by the mine regulator in September 1996, and it's been varied several times, with the most recent variation taking place in 2009. The approved work plan for the mine reflected the work plan submission which had been submitted by the Hazelwood Power Corporation in June 1995. There were two clauses in that submission, and the submission, of course, ultimately became the approved work plan, which are relevant to fire mitigation. 7.4, which deals with bushfire mitigation, the bushfire mitigation program, which I won't read out, and 7.7, which deals with the fire protection policy. Under the heading Fire Protection Policy, the submission, and therefore the approved work plan, states as follows: HPC adheres to the Latrobe Valley Open Cut Mines Fire Service Policy and Code of Practice issued April 1994. The Fire Service Policy and Code of Practice contains the essential requirements and operating procedures for fire protection services for the mine and its surrounding area. An extensive network of water reticulation and sprays has been established in the mine for fire protection. And then there's a reference to Figure 13, capital A, Fire Service Network Schematic. This has been referred to in evidence before the inquiry. It's a schematic that depicted the fire reticulation pipe network in place in the mine at that time, that is, at the time of the approval in 1996, and it depicted a network that surrounded the mine. This has already been referred to today by my learned friend Ms Richards, but the evidence before the inquiry establishes that the reticulated water network at the mine was extensively altered from about 1995 onwards, extensive particularly in the area of the Northern Batters. The evidence of Mr Polmere from GDF Sewers is to the effect that the pipes were removed. The pipes that were removed were in the Northern Batters part of the mine. Mr Polmere explained that the pipes which were removed were corroded and unserviceable, and council assisting submit that it will be accepted that that was a legitimate basis for their removal. However, the more important question is why the pipes were not replaced once they were removed. And it will be recalled that Mr Polmere was asked this, and his answer, and I quote, is they didn't need to be in accordance with the policy, end quote. The policy referred to by Mr Polmere is the Fire Service Policy and Code of Practice issued in April of 1994. The inquiry heard from a bushfire fire expert, Mr Incoll, and he explained, and I quote, that effective cover of exposed coal surfaces with water sprays requires a reticulation system capable of delivering water in the volumes required for dampening down of exposed coal in all sectors of the mine, close quote. It's important to appreciate that the reticulated water supply in a mine such as the open coal mine at Hazelwood serves at least two purposes. Firstly, it serves the purpose of being able to prevent fires, that is, the wetting down of the coal surfaces on high fire danger days reduces the risk of a fire starting in the first place. And the inquiry's heard from a number of witnesses right back to Mr Brown on day one about the historical wetting down of coal surfaces so as to prevent fires. But of course the pipe water also assists in the suppression of fires once they are started. So the pipe network clearly serves a dual purpose both in relation to prevention and suppression. Returning to Mr Incole's evidence, he noted that the difference between the pipework in 1996 and that in 2014 indicated that the northern batters supply is no longer in place. It is of course recognised that during the firefight itself, considerable additional pipework was placed in the northern batters area, which an examination of the maps before the inquiry shows that the pipework that was reinstated was in much the same area as where the pipework had been removed. Returning to the policy that Mr Palmier referred to, it has since 1994 set out minimum requirements for fire protection in the worked out batters. The words minimum requirements are important because that is just what the code stated. They are the minimum for fire protection. The current requirements are in section 3.4 of the most recent iteration of the document, the 2013 code, which is before the inquiry. The principal requirement is to have tanker filling points located in positions such that a tanker on any part of the worked out batters is within 5 minutes travel of a tanker filling point. On the evidence before the inquiry, it's unclear if even this minimum requirement was met by GDF sewers. Mr Palmier believed it had when he was asked. He assumed that some testing had been done to confirm compliance, but no document evidencing such testing has been placed before the inquiry. In any event, tanker fill points are only relevant to fire suppression, not its prevention. What is needed for prevention, as Mr Incole explained, is either covering of the batters with soil or some form of fire retardant or water to wet down the worked out batters on days of high fire danger. Perhaps of greater significance is what Mr Palmier's evidence reveals about the historical approach of GDF sewers to its responsibilities to manage the risk of fire in the worked out parts of the mine. The inquiry has heard that sewers is certified to Australian and New Zealand standard 4801 concerning occupational health and safety systems. Despite that, there's no evidence that GDF sewers conducted any risk assessment to examine whether the removal of the pipes, that is the evidence of Mr Palmier, contributed to a reduction in the level of fire preparedness or mitigation and hence of safety. As Professor Cliff explained in his evidence to the inquiry, the failure of GDF sewers to assess the risks associated with the removal of the pipework is both unacceptable and inconsistent with the approach to be expected of a company certified under Australian Standard 4801. As Professor Cliff said, to say we don't do it because we don't have to is not a management technique. The evidence is the policy was updated by GDF sewers in the years after privatisation. The mine production manager, Mr Dugan, explained that the 2013 iteration of the Mine Fire Service Policy and Code of Practice is based upon the 1994 document, which is in turn based on the 1984 SEC Latrobe Valley Open Cuts Fire Service Policy. Mr Lapsley's attention was drawn to this evidence, that is, that the present code dates back to a 30-year-old document. He described that as amazing. From Council Assisting's perspective, it is at the very least concerning that what's in place currently is really no more than an updated version of a document that was produced 30 years ago in circumstances where it applied to all three of the open cut mines, which were then, of course, being run by the SEC. I'll return to this issue in our recommendations. Surprisingly, the removal of the pipe network on the northern batters was not the subject of an application to vary the work plan. It will be recalled that the work plan includes a schematic of the pipework as it existed in 1995. Ms White of the mine regulator gave evidence that such work would have to be by way of a variation to the work plan. However, she also agreed with the proposition advanced by counsel for GDF sewers that as long as the standards in the 1994 code continued to be met, that would constitute compliance with the requirements of clause 7.7 of the approved work plan. Ms White also told the inquiry that as far as the mine regulator was concerned, GDF Sewers had not breached any of the provisions of the Mineral Resources Sustainable Development Act. And counsel assisting submits that on the basis of the evidence before the inquiry, that conclusion would appear to be correct. Turning then to some recent amendments to the Mineral Resources Sustainable Development Act, which are of significance as far as future management of these risks is concerned. The Act is the subject of recent amendments of significance for the inquiry. The Mineral Resources Sustainable Development Amendment Act 2014 amends the Mineral Resources Sustainable Development Act by inserting a new Section 40. Section 40 is the provision that's concerned with the requirements for there to be a work plan. This is a complicated set of amendments to understand. Summarising them the best we can, there are essentially two sequential amendments to Section 40 that are affected by the Amendment Act. The first is affected by Section 16, and it need not concern us, but that amendment takes effect on the 1st of November this year. More importantly is Section 16, which further amends Section 40 by inserting a new subsection 3. This further amendment will not be operative until 31st of December 2016 unless it is earlier proclaimed. And the inquiry will recall the evidence given by Ms White about the need for there to be regulations in place before those amendments take effect. Importantly, once Section 16 of the Amendment Act is proclaimed, a work plan will be required, among other things, to identify the risks that the work may pose to the environment, to any member of the public or to land or property in the vicinity of the work, and specify what the licensee will do to eliminate or minimise those risks as far as reasonably practicable. I'll return to the significance of those amendments in terms of the recommendations that counsel assisting submits ought to be made to ensure that in the future these risks are appropriately managed. Before doing that, I need briefly to refer to the topic of integrated fire management planning, which has been the subject of some evidence before the inquiry and is obviously an important part of the fire prevention and mitigation puzzle. The evidence before the inquiry is that integrated fire management planning occurs relevantly at both regional and local level. Mr King, the Coordinator of Emergency Management at the Latrobe City Council, gave evidence that integrated fire management planning involves looking in more depth at risks associated with fire on an all-agencies approach and including the owners of critical infrastructure. The inquiry has before it the Gippsland Regional Strategic Fire Management Plan and also at the local level the 2011 and 2013 Latrobe Municipal Fire Prevention Plans. Of significance to the inquiry is the question of effective implementation of these plans. The evidence suggests the plans are not implemented at all, nor have they been reviewed by the affected agencies to check that the suggested treatments are possible or within the jurisdiction of the agencies referred to. Mr Incoll dealt with the issue in his standard common sense way. He said there's no enabling legislation that says once you've made that plan, here's how it's going to be implemented. Mr Lapsley gave similar evidence and so did Mr King from the council. Mr Lapsley was asked if he could assist in relation to providing an answer. He suggested the first step was to modernise the legislative basis for fire management planning, and council assisting accepts Mr Lapsley's characterisation of integrated fire management planning as a necessity, and the inquiry ought note his commitment in his new role as Emergency Management Commissioner to continue to drive the process. The evidence before the inquiry was the mine regulator plays no role in integrated fire management planning at any level. Ms White of the mine regulator said it was the responsibility of the VWA. Mr Neast of the VWA saw no problem with the VWA not being referred to as one of the existing treatments in the regional plan. His evidence was the plan was concerned with the protection of infrastructure and not saving was not concerned with health and safety in the workplace. It is submitted that this response demonstrates the gap in a practical sense that exists in integrated fire management planning. On a related topic, there is some evidence before the inquiry about Section 43 of the Country Fire Authority Act, and it will be recalled that it imposes a general duty on councils and public authorities to take all practicable steps to prevent the occurrence of fire and minimise the danger of the spread of fire. It's a historical anomaly that before privatisation, that provision applied to the Hazelwood mine. Subsequent to privatisation, it does not. It's submitted that the position is anomalous, that the only reason the provision has no application to a piece of critical infrastructure like the Hazelwood mine and power station is because they're not publicly owned. This is the subject of a recommendation which I'll come to. I note that Mr Lapsley agreed with the suggestion that consideration should be given to extending the reach of Section 43 along the lines suggested, which is that it ought to apply to critical state infrastructure regardless of whether it's publicly or privately owned. I can turn to the important topic of filling the regulatory gap. It'll be recalled that council assisting submissions is based on the evidence before the inquiry. There is a regulatory gap in relation to the impact on public safety of fires that do not arise from the conduct of the undertaking of the mine operator. The evidence in the inquiry has raised a number of concerns about the manner in which the Work Cover Authority has exercised its regulatory powers in relation to OHS at the mine, particularly concerning the risk of fires in the worked out parts of the mine. We've listed some of those concerns, and they do call to mind Professor Cliff's reference in his report to the difficult position a generalist OHS regulator is in where it is regulating a small mining industry. And it will be recalled that Professor Cliff's evidence is that in what he called the mining states, New South Wales, Queensland and Western Australia, there is a dedicated mines inspectorate that is concerned with OHS as well as other aspects of regulation of mines. Victoria, like the position in New Zealand, has a generalist OHS regulator that is responsible for a small number of mines. The reference to New Zealand is significant because Professor Cliff, based on his experience of the Pike River disaster in New Zealand, was able to refer the inquiry to the difficulties faced there by a very small Department of Labor inspectorate dealing with a relatively small mining industry. Aspects of the evidence that are concerning in this regard are listed in para 72 of the findings, and they include that the large-scale transfer of staff from the mine regulator to the VWA that was recommended in the Pope report didn't occur. No explanation was provided to the inquiry of why the staff that were recommended to transfer across to VWA, bringing with them obviously the experience and knowledge of the mining industry, with one exception, I think one of the inspectors did transfer across, but otherwise it seemed that didn't happen. Similarly, it seems the transfer of files. There's a recommendation in the Pope report that there be electronic access to the mine regulator's files. The evidence of Inspector Hayes, was that he did not have access to pre-1st of January 2008 files. There is also the evidence of the failure to monitor the implementation of the recommendations in the 2008 GHD report that were referred to earlier. And finally, there is the less than thorough manner in which the question of compliance with Regulation 5.3.23 by GDF Sewers was examined or overseen in that process referred to earlier. Both Mr Neast and Ms White were asked about the future of the regulation of fire in the mine. Mr Neast accepted that his Earth Resources team at the VWA needed to be supported with system safety specialists to assist them in judging whether risks are being properly controlled. He's committed to addressing this deficiency, as he perceives it, in the Work Cover Authority, and that is a matter that is to be commended. Ms White suggested the mine regulator, the VWA and the fire agencies could come together to discuss what possible changes were needed. She also made a number of suggestions concerning the rehabilitation timetable, while noting that rehabilitation can have an indirect effect on mitigating fire risk. Ms White also accepted that the amendments to Section 40 of the Act she administers that were discussed above will require a licensee to engage in, quote, a much broader assessment of risks than we currently have now with the work plan that I have to currently oversight. Council Assisting submits that the amendments to Section 40 of the Mineral Resources Sustainable Development Act provide an opportunity for the mine regulator to re-engage with regulation of the risk of fire in the mine generally and in the worked out areas of the mine specifically. It's our submission that it has been an unfortunate and perhaps unforeseen side effect of the transfer of occupational health and safety regulation to the VWA that the issue of public health and safety has been given far less priority than it should have been. The inclusion of risk management in approved work plans provides an opportunity for this to be addressed. It's relevant in this regard that the test in the new Section 40, subsection 3C, is consistent with that used in the Occupational Health and Safety Act and the regulations. That is, risk will be required to be controlled so far as is reasonably practicable. This should enable the mine regulator and the VWA to approach their respective regulatory tasks consistently. It may be said that if this approach is followed through, that there will be an overlap between the areas of responsibility of the mine regulator and the VWA in this regard. To that observation, Council Assisting make the simple response that it is preferable to have an overlap than for there to be a gap. One thing that is of concern is the time frame for the implementation or the coming into operation of the new provision. The evidence before the inquiry is that the amendment may not be operational until December 2016. The people of the Latrobe Valley and Morwell in particular are entitled to see any regulatory gap closed at the earliest opportunity. It is unclear if existing work plans, such as GDF Suez's, will need to be revised to meet the new requirements. Ms White was asked about this and informed the inquiry that there will be a transitional phase, but it is not entirely clear what is envisaged. The Amendment Act at the moment does not provide any detailed answer to that question. Significantly, Ms White also noted that the changes will, and I quote, flag a very strong intention to change the approach to work plans, and given that this is already in the public domain, I would consider that a mine operator would consider this in light of what they are doing today. Council Assisting submit that the impending change to Section 40 and the requirement to address risk in a broader way in work plans presents a real practical opportunity for the industry and GDF Suez in particular to seize this opportunity to put into effect some of the things that Mr Graham said were being examined in the evidence that he gave to the inquiry. To use a colloquial expression, it's an opportunity for GDF Suez to put its money where Mr Graham's mouth is. It is to be hoped that GDF Suez grasped that opportunity. We also submit that the inquiry should ask the Victorian Government to bring forward the commencement date of Section 16 so that it commences as soon as possible. If work on regulations has to be done, it's difficult to see why that should take 2.5 years, given the significant risks that this inquiry has been examining. We also consider that the changes present an opportunity for GDS to give effect, as I've said, to the commitments made by Mr Graham. That is to embrace a best practice continuous improvement approach throughout the mine, including the worked out areas, rather than the minimum compliance approach about which evidence has been given. Before turning to the proposed commendations and criticisms, I'll refer briefly to land use planning. It is an area about which evidence has been given to the inquiry, and Council Assisting note that there's a large gap between the fire protection policies outlined in the Latrobe Planning Scheme and the reality of land use in the vicinity of the mine as the inquiry has heard about it. It is trite to say there's no buffer zone between the mine and the town of Morwell, despite the provisions of the planning scheme requiring a buffer zone of up to 1,000 metres. It's also noteworthy that there are at least 3 timber plantations within a kilometre of the mine licence area, and disturbingly, as Mr Incoll emphasised, they're all to the west of the mine, perfectly located to enable them to catch fire and potentially throw embers into the mine. Although the scheme currently provides that a permit is required for timber plantations in the special use zone and the public use zone, the council has no records of permits being issued in respect of the plantations. Land use planning can be an effective means of reducing fire risk, but it's a long-term measure and can only operate prospectively. It should at least be possible to ensure that no further timber plantations are established in close proximity to open-cut coal mines, particularly in the vicinity of their western perimeter. Turning then to the commendations that Council Assisting submit ought to be made. Firstly, GDF Sewers is commended for recognising through the evidence of Mr Graham that it needs to adopt a new approach to the management of risk of fire in the worked-out matters of its Hazelwood mine. The inquiry has before it a document prepared by Mr Graham, which he spoke to, and it will be recalled that it was a document of relatively recent origin, and it's apparent that a great deal more work needs to be done, particularly in relation to internal discussion of that within GDF Sewers and external communication with regulatory agencies and others. But it is a commendable start. Secondly, the VWA is commended for recognising that its Earth Resources Unit needs additional resources to fulfil its functions under the regulations and Act that it administers. Turning to criticisms, firstly, GDF Sewers is criticised for not meeting its obligations under the Occupational Health and Safety regulations to assess the risks associated with fire in the worked-out matters of the mine in accordance with Regulation 5.3.7, to control those risks in accordance with Regulation 5.3.73, and to review those measures after the fire in a non-operational part of the mine in September 2008, as required by Regulation 5.3.92b. GDF Sewers should have implemented Recommendation 6 of the GHD report into the September 2008 fire by conducting a risk assessment into the risk of fire in the non-operational parts of the Hazelwood mine. Thirdly, GDF Sewers as an international company accredited to Australian Standard 4810 should not have adopted the approach of minimum compliance to the risk of fire in the worked-out matters of its Hazelwood mine, but rather should have taken a full risk assessment of key risks to the mine and possible controls to minimise the likelihood or consequence of the various risks occurring. Turning then to the proposed recommendations, and there are 7. The first is that GDF Sewers should ensure that it embraces a sound enterprise risk management framework that considerably enhances a more sophisticated corporate culture in respect of the management of risks. And as has been noted, Mr Graham's evidence to the inquiry would seem to suggest that there is a recognition that that is desirable. Secondly, GDF Sewers should engage reputable external consultants to conduct a thorough risk assessment of the likelihood and consequences of the risk of fires in the worked-out matters of the Hazelwood mine. The assessment must consider the most effective fire protection for the exposed coal services, including final rehabilitation, water coverage, coverage by earth or some other substance, treatment with a fire retardant, or a combination of these or other approaches. GDF Sewers should implement the suggestions in the report concerning controls and treatments to minimise the impact of the risk. Thirdly, GDF Sewers should thoroughly review its mine service policy and code of practice to ensure that taking a risk assessment approach, it is suitable for mitigation, prevention and suppression of fires in all parts of the mine. The reviewed policy should, as a minimum, address the regular removal of vegetation, matter discussed by Mr Incoll, the ability to prevent and suppress any fires that commence or burn into the worked-out parts of the mine, the use of thermal detection and other imaging technologies by which fires can be spotted as soon as they commence, and the ready availability of compressed air foams that are capable of operating in an open-cut mine environment supported by camera and other technologies. And the review document ought to be incorporated into the approved work plan for the mine. Turning to the regulatory structure from the date upon which Section 16 of the Mineral Resources Sustainable Development Amendment Act 2014 commences, the issues of fire prevention, mitigation and suppression should again be addressed in approved work plans under the Mineral Resources Sustainable Development Act 1990. This will mean, importantly, that from that time, both the DSDBI and the VWA are responsible for regulating the risk of fire in mines, the DSDBI being able to bring its extensive mines expertise and the VWA drawing on its occupational health and safety management expertise. Fifthly, the Emergency Management Commissioner should assume responsibility for integrated fire management planning in Victoria from 1 July 2014 and should sponsor legislation that will underpin integrated fire management planning and provide legislative authority for the development and implementation of regional and municipal fire management plans. 6. Section 43 of the Country Fire Authority Act should be amended so that it applies to essential state infrastructure such as the Hazelwood Mine and Power Station, whether they're in private or public ownership. And the final recommendation that we submit ought to be made is that the Department of Transport, Planning and Local Infrastructure and the Latrobe City Council should review the Latrobe planning scheme to ensure that, so far as is reasonably practicable, it minimises the risk of embers from external rural fires, in particular timber plantations, from flying into open-cut coal mines in the Latrobe Valley. They're the submissions that we make in relation to this matter, and unless there are any questions that members of the board have about the topics that I've addressed, it's probably time to give the parties a chance to say something.
I just had one question, Mr. Rosen, about, again, this sense of urgency, whether you have a view about timelines or speed of action.
I anticipated you might ask that question, Professor Catford. Most of the recommendations that we make in the two topics that I've addressed, that is firefighter safety and the regulatory arrangements, are recommendations really which ought to be addressed as a matter of urgency. The one recommendation where that may not be possible concerns the coming into operation of the Amendment Act and including in approved work plans the matters of fire risk and other risk management. But it would be hoped that that could be addressed if there's some flexibility about the commencement time frame for those amendments. Thank you. If the board pleases.
The board pleases. May I start by just making some general observations about Environment Victoria's position and the approach I intend to make to these submissions. Environment Victoria submits that the fire itself, or at least the extreme extent of it, was avoidable. It was avoidable by the adoption of mitigation measures, and by the adoption of those same mitigation measures, a repetition of the event in the future can be greatly reduced, or the prospect of that can be greatly reduced. Environment Victoria has a limited remit in terms of its grant of leave. We are granted leave in relation to the question of mitigation, and we do not intend to repeat what has been submitted by Council Assisting. On the question of mitigation and the regulatory issues associated with mitigation, Environment Victoria adopts and supports the submissions of Council Assisting. I will focus in these submissions on the question of rehabilitation of the mine. It's Environment Victoria's submission that rehabilitation of the mine is a powerfully effective tool to protect the community against the risk that happened on February 2014 from ever happening again. There is no doubt the obligation of GDF Sewers that it had to progressively rehabilitate the mine can be accelerated, and there is no good reason why it should not be accelerated for the purposes of mitigating fire risk. A sensible question and a necessary one, is what is a good and practicable way to de-risk a brown coal mine against fire risk. In our submission, rehabilitation, meaning accelerated progressive rehabilitation, is a solution which must be given considerable weight when answering that question. In short, for these reasons, its risk mitigation potential is both powerful and well known, and once it's done to the parts of the mine in which it occurs. Second, it's a tried and true method in which the operator of the mine has undoubted expertise. It's not new, it's known. Third, it's already the subject of a statutory obligation. That obligation, as has been acknowledged by GDF Sewers in its evidence, is the quid pro quo for the licensee's right to dig coal out of the ground and to do it in such close proximity to the township of Morwell. It's a core obligation under the Act to progressively rehabilitate in the course of doing the work. Mr Faithful accepted that obligation was, in his words, part and parcel of being a community-wise and environmentally wise mining business. Rehabilitation costs money, and it's complex, like every other aspect of mining. A lot has been said about cost, and it's really cost that's implicitly behind the resistance of GDF Sewers and aspects of the regulatory regime to accelerating rehabilitation. It's not suggested that cost is irrelevant. It's not suggested for a moment. But in basic terms, there are some fundamental economic relationships that need to be observed in our submission. First, what happened in February of this year was one of the worst public health and environmental disasters in the state's history. The costs to the community were vast. And there is, of course, if mitigation measures are not taken, a risk of repetition, carrying with it risks of very significant costs. On the question of costs, rehabilitation is a cost, the cost of rehabilitation rather is a cost that the mining company must already incur. Of course, there are incremental costs attached with doing it sooner, accelerating it, but those have not been quantified. There's not been a scintilla of evidence from GDF Sewers about how much more it will cost to do it more quickly. The third element of cost is that there is presently much less financial incentive on GDF to accelerate remediation than there could be. And there's much less financial incentive on it to get the job done in its entirety before the mining licence finishes. And that's the issue of the rehabilitation bond. Rehabilitation as a fire mitigation measure has affirmative support from some important witnesses. Mr Lapsley said that to improve the efficacy of the current fire mitigation measures, there should be a review of the rehabilitation regimes in and adjacent to the mine for mitigating fire entering and leaving fire mine sites. That's an important piece of evidence for the board it is submitted. Mr Neist accepted, after being cross-examined, that the question of reasonable practicability was not off the table when it came to rehabilitation for the purposes of mitigating fire risk. Ms White from DDSBI accepted and welcomed the potential enhancement of the powers under which her department operates to include rehabilitation specifically for the purposes of fire risk. It's really GDF alone who does not really offer anything more than what it was previously doing. In these submissions, it's accepted that the board must necessarily focus on solutions for the future, and it's in that context that we do make some criticisms, do submit that the board ought make some criticisms about events that have happened in the past, but it is for the purpose of improvement rather than for blame. The question of rehabilitation and its role in things is necessarily tied to aspects of the regulatory regimes, and for that reason we make some submissions about parts of those regimes. We submit that the board needs to take a multi-pronged approach. It's not really a question of whether there is one single right way of fixing fire risk. Rather, amendments to the regulatory regime and recommendations attaching to GDF need to be as fulsome and multifaceted as is possible. We say this for these reasons. Both the mine operator and the regulators have evidenced a tendency to too readily draw demarcation lines around their particular area of operation and to ignore the question of fire risk. The other reason is that on the question of rehabilitation, if we may say so with respect, the attitude of the mining company is that it's all too hard, it's too difficult, it's very costly, and we would prefer to stick to our plan. It's necessary that some of the recommendations that the board will ultimately make will need to provide for further reviews and inquiries. An important theme of the evidence in our submission is that in the past, reviews, inquiries and processes have really been exactly that, reviews, inquiries and processes, and they have not really led, in many cases, to practical outcomes. For that reason, Environment Victoria goes further than Councillor Sisting do on the question of recommendations concerning rehabilitation of the mine. In our submission, the board ought, insofar as it can, be pointed, practical and specific in its recommendations. We've indicated to Ms Richards that we will supplement our oral submissions in writing. Given that, I will just refer in fairly general terms to the evidence so as not to take too much time. We will also, in our written submissions, set out the precise recommendations that we propose. However, I will address those orally as well. Having made those general remarks, there are 10 propositions that in our submission support a very serious consideration in relation to rehabilitation of the mine for the purpose of preventing fire risk. I hope that you're not alarmed by the number 10 because I can go through them quite quickly. The first proposition is this, that fire was a reasonably foreseeable consequence of unrehabilitated batters. I don't need to go into the evidence supporting that proposition because it has been done by Councillor Sisting. Suffice it to say that in our submission there appears to have been significant institutional knowledge failure on behalf of the operators of the mine. The risks to the community of Morwell were never taken seriously. A statement from Mr Graham exemplified that attitude when he said in giving evidence, "Now it has been proved that this thing can happen." That sort of attitude, we say with respect, completely misunderstands the role of risk management. Both DDSBI and the Victorian Work Cover Authority were also sufficiently aware of the relevant risks. The second proposition is that there is a very clear link on the evidence between rehabilitation of the mine and mitigation of fire risk. The evidence, and I mention it only briefly, comes from Mr Incole, who said that exposed earth needs to be covered by earth, Mr Cliff, Mr Neist, who accepted that covering coal is good for fire risk mitigation, Mr Faithful, and importantly in the work plans of 1996, 2009 and passingly in the work plan of 2013. It's really quite unsurprising that in the work plan of 2009 there's a very clear link drawn between rehabilitation of batters by covering them with overburden and fire risk. It's because that's a very natural connection. The risk is caused by stripping away earth from coal batters. It's fixed by rehabilitating the mine. The alacrity with which both GDF Sewers and the regulators sought to step away from section 6.5 of the work plan was breathtaking. third proposition is that there is a fundamental obligation to progressively rehabilitate on the mining operator. But that obligation has in practical terms been attenuated by a very weak rehabilitation plan that contains no real milestones. The obligation to progressively rehabilitate is a core obligation under the Act. It finds its effect in the mining licence. But in that context, what has happened is that the substance and effect of the obligation necessarily depends on the quality of the work plan. The licence ties progressive rehabilitation, of course, to an approved work plan. The 2009 work plan, in short, allows 4 stages of overburden rehabilitation, and it's tied to the availability of overburden within the mine. Now, that is one important consideration, but in our submission it ought not be the only consideration. What it means is that progressive rehabilitation is not required to be done until, on the most optimistic view, overburden becomes available as a byproduct from mining operations. That document is a key regulatory document. The most stunning example of there being no clear milestones in that plan was exhibited in the difference of view between Ms White of DDSBI and GDF Sewers, when on the very important question of when the next phase of rehabilitation would be done, there were diametrically opposed views. And according to Mr Faithful, the regulator's expectation had never been discussed. If ever there was an example of the cooperative form of regulation breaking down, that is it, and it needs to change in our submission. The fourth proposition is that the attitude of GDF Sewers on the question of rehabilitation has been one of blindness to the obvious link between rehabilitation and fire risk mitigation. Mr Faithful's evidence was important on this score. He is the person practically in charge of rehabilitation, and rehabilitation very obviously is the most major practical, significantly effective means of mitigating fire risk. When he was asked about the 2009 plan, he didn't recognise it, barely. He had not turned his mind to the link between fire and rehabilitation. When he was asked about the alternatives for fire risk mitigation, he accepted that there were 2, extinguishment or insulation. His working assumption was that where batters are not covered, they will be covered by the fire service, but he had made no inquiry about whether the fire service would operate effectively. Proposition 5 is that the complexities and costs described as impediments to rehabilitation are not really impediments. They're simply complexities and costs that occur in the nature of a mining enterprise and are intrinsic to rehabilitation. They are not such as should, in my respectful submission, encourage you not to make strong recommendations about rehabilitation. Mr Faithful agreed that the stages in progressive rehabilitation that he identified in his witness statement must occur ordinarily, regardless of when remediation is done. He said that none of the steps identified could not be done in a progressive sense. He simply said that it was costly and complicated. He asserted in very general terms that there would be increased costs if the progress of rehabilitation was taken out of sync with the existing mining plan. Now, it doesn't take long to imagine why it is important that the progress of winning coal needs to have a good relationship with rehabilitation. It doesn't follow, however, in my submission, that one can never change the plan for rehabilitation including by looking at the plan for mining coal itself. There were no particulars provided about the incremental cost. And on the so-called practical constraints, when Mr Faithful was asked about whether or not he could or couldn't move infrastructure, which was a major reason, apparently, for not accelerating rehabilitation, he said, "I haven't checked." One of the issues was the availability of overburden. There is a high proportion of coal to overburden in the Hazelwood mine. Ideally, GDF Sewer's position is that it would want to use the overburden that is close to the areas that it is rehabilitating. That is an understandable preference. But in our submission, preferences cannot always be met, and that preference is not a reason to assume that because of the availability of overburden, rehabilitation cannot be accelerated or the sequence in which it be done changed. Proposition 6 is that there is in fact a clear opportunity to change the rehabilitation plan and to accelerate it. Just pausing on the question of overburden, Ms White said interestingly that DDSBI had been discussing, I think with VWA, whether it would be possible to get overburden from the overburden dump within the mine. The board is not in a position presently to know the results of those conversations, and they did sound rather preliminary. But that is a question that is being asked, and in our submission should be asked. It is clearly possible to investigate whether there are other sources of overburden, whether overburden, for example, can be obtained from parts of the mine and used to rehabilitate, other than simply in the way it is done now, which is that overburden is only obtained in the course of extracting coal and used close to the area in which the coal extraction occurs. Ms White said that she would welcome the opportunity to consider whether the rehabilitation plan can be amended so that rehabilitation can be brought forward. She also said, however, that there are a number of issues to consider and that GDF are responsible for determining whether and to what extent the program can be brought forward. She made the point that it's GDF who has the technical expertise rather than the mine regulator. That's a point that is of real concern. It's not suggested that Ms White's concerns about resources were not valid or genuine. However, if the mining regulator does not possess sufficient expertise to keep ahead of the mine operator, the end result is that from a regulatory perspective, no one is leading and the mine operator has the opportunity really to run its own race. It will necessarily, and on one view quite properly, have at the forefront of its mind its own commercial considerations. But in a context such as this, it is absolutely important in our submission that the regulator play a leading role. And when the mining regulator has expressed the view that change is welcome, but that there is a concern about expertise, and that ultimately the question of whether rehabilitation is brought forward is a question for the mine, that is not in our submission an appropriate state of affairs. On the question of timing, we make two submissions. One is that the schedule for rehabilitation should be the subject of a major review to see what areas of the mine can be rehabilitated sooner, specifically with a view to fire mitigation, and the question about the sequencing and the structure of the plan itself be reviewed. On this count, it should be noted that what's being offered by GDF in the document put forward by Mr Graham the other day is in fact nothing new. The 9 hectares identified to be rehabilitated are those that were already identified for work in January 2014. The second submission we make is that even if, and to the extent that for the time being, the existing plan stays in place, there are a number of things that can happen to assist the timing of rehabilitation. First, it's been made pretty clear that the department expects that, for example, the 2019 phase of remediation should be completed by 2019, subject to the progress of the mining works themselves. The GDF has a different understanding. It is preferable in our submission, clearly, that the department apply a requirement the works be completed rather than commenced by that date. Within that rubric, it is important that the department impose upon GDF some clear time milestones. It was plain from the evidence of Mr Faithful that very little has been done, if anything, to progress the next phase of rehabilitation. The 4 stages of rehabilitation do not all require overburden. Stage 1, for example, involves assessment of stability. That could be done. There's no reason why it could not. It has not been started, and there was no reason why it has not been started. That example illustrates why it is necessary and appropriate in our submission for the department to start imposing some real milestones that are concrete, that are tied to specific activities and are based on time. That kind of regulation may not suit the preferred regulatory style of DDSBI, but in our submission it's not appropriate at all for a general preference for a regulatory style to prevent proactive regulation in these circumstances. Proposition 7 is that there are certainly alternatives to rehabilitation as a fire mitigation measure. Presently, these are untested, and the evidence about them before the inquiry, when taken in the context of the evidence about rehabilitation, should lead to the conclusion that a major emphasis on rehabilitation should be made in the board's findings and recommendations. You will recall the evidence of Mr Faithful when he was re-examined by Ms Doyle, and he identified in series a number of practical objections and concerns about temporary rehabilitation measures. Now, we don't suggest or submit that those concerns ought to be taken at face value at all. However, in contrast to rehabilitation, those measures were said to raise a number of specific issues. Clay capping was said to potentially interfere with access to roads, drains and horizontal bores on batters. On the question of a system to wet down batters, reticulated water systems are obviously an important consideration. We are not in a position, and I don't think Council assisting are either, to make detailed submissions on what a reticulated water system would look like and how effective it would be to mitigate risk. We do note, however, that considerations might arise to do with electricity supplies to that water system. It is true that technology that requires power can fail at critical times. Rehabilitation, however, although it is complex, although it involves a process, once it is done, it is done. I commence these submissions by saying the board should embrace and make recommendations in a multi-pronged approach. So it's not our submission that one should make recommendations only about rehabilitation of the mine, but not to make strong recommendations about rehabilitation of the mine would be remiss, and certainly there is no evidence that any alternatives to rehabilitation would be as powerful or as effective as a fire mitigation measure. The eighth proposition we have is that there have been significant failures or limitations in the regulatory regime which fracture the natural relationship between rehabilitation and mitigation, the effect of which is to effectively allow the mind to run its own race. And by failures we mean either limitations in the regime itself or in the way the regime is applied. For the purposes of making recommendations for change, it matters not. However, a close analysis of those limitations is important in order to guard against the same kind of errors that have happened in the past. And as I said in the beginning, we adopt council assisting submissions on the regulatory regime, but we do want to make some observations. Prior to the fire, neither DDSBI nor the VWA considered it was their responsibility to ensure that appropriate fire risk assessment and management was undertaken specifically in the context of the worked out areas of the mine in order to protect the population of Morwell. There is a slight caveat to that in the case of the VWA, in that if it considered that Section 23 applied to the operations of the mine in the particular context of the relevant cause of fire, then it would regard itself as having an obligation. The position of DDSBI and Ms White has been summarised by Mr Rosen. The mining regulator's position was indeed very stark and it perhaps surprising. The position was taken notwithstanding that the objectives listed in Section 2 of the Mining Resources Sustainable Development Act are, amongst other things, to establish a legal framework aimed at ensuring that mineral and stone resources are developed in ways that minimise adverse impacts on the environment and the community, and that the health and safety of the public is protected in relation to work being done under a licence. There was a quite concrete example of risk being made quite plain to the department that appeared in Ms White's witness statement, and that was when the 2009 plan was being changed and there were amendments to the Latrobe planning scheme. The panel convened to consider the EES gave great attention to the question of fire risk, and it was said that DSE itself had recommended in the course of that inquiry that batters be flattened and capped for rehabilitation purposes, but also, and I quote from Ms White's statement, from the extract in Ms White's statement, to achieve the not insubstantial benefit of mitigating the risk of fire. Whilst it is understood that those who have regulated have done so because they take probably a conscientious view about the limitations of the field in which they operate, it's nevertheless quite extraordinary that this kind of risk can be sidelined and effectively ignored because a view is taken about the parameters of the field in which the regulator operates. It is important, however, in the context of recommendations that DDSBI recognised that change could occur, and Ms White said she was not unwilling to accept change. It was said, however, that, to quote her, we don't have fire expertise. Our submission is that in order to progress rehabilitation as a fire risk mitigation measure, no more fire expertise is needed or no more knowledge is needed than currently exists. The mine operator has all the expertise it needs in rehabilitation, and so ought the department. Nothing more needs to be known about the potential for rehabilitation to mitigate fire risk. It's not said in our submission that either GDF or the VWA should not obtain extra resources and expertise. In fact, they should. but the acceleration of rehabilitation as a fire risk mitigation measure does not need further expertise, more learning, more knowledge. In answer to a question by Professor Catford about who determines what gets remediated and when, Ms White said, in effect, that she did not regard her department as a passive regulator, but the answer was really that it was the responsibility of GDF for preparing and implementing the plan. Now, that might be true as a matter of technicality, but one must ask again, who leads and who is responsible? Who asks the hard questions? Who thinks outside the square? There is a vacuum here that has had very real consequences and needs to be fixed. Ms White indicated, however, that she welcomed reform, as I've said. Mr Rosen has already addressed Section 40, subsection 3, and we support Councillor Sisting's submissions and proposed recommendations in that regard. Ms White took a very limited view of her role, and I don't mean this personally, it's a view that represents the department's position, because of the description of, I say this in the context of rehabilitation, because of the description of what ought to appear in a rehabilitation plan in the regulations, Schedule 15 of the regulations made under the Mineral Resources Sustainable Development Act. In our submission, Ms White's reading of that schedule was very limited indeed, and a broader reading is more than open and indeed correct. We needn't dwell on that, however, because Ms White said she would be happy for an amendment to be made. In the context of the VWA, we won't repeat Mr Rosen's submissions, but we do note the very, very narrow interpretation given to Section 23 and the qualified answer to the question, who protects against the risk of fire? The answer being, well, it depends which precise risk is being protected against. Proposition 9 is that rehabilitation is a reasonably practical measure for the mitigation of fire risk, and at the very least, on the evidence before the board, it cannot be excluded as not being a reasonably practicable measure. And as you know, whether it is a practical measure for mitigation goes to the obligations on GDS under the OH&S Act and regulations. Mr Neese started off putting quite confidently the view that it was likely that rehabilitation and also the construction of a reticulated water system would not be reasonably practicable measures. It's of some concern that both of the major potential rehabilitation measures were dismissed in this way. Mr Neese's ultimate conclusions were that it could not be concluded that rehabilitation is not a reasonably practical measure that could be used to control the risk of fire in the mine. Mr Neese said that clearly after the fire all of the parameters have changed. It is now known that it can occur, so the whole risk has to be reassessed. Now one must ask what really had changed, but focusing on solutions. At the very least, on the evidence, including Mr Neese's evidence, it must be accepted that rehabilitation is a very strong contender for being a reasonably practicable measure. I won't labour the points in Section 20, subsection 2 in the interest of time, but if I may just remind the members of the board about a couple of important pieces of evidence. On the likelihood of the risk eventuating, just going through the factors, Mr Neese agreed that the likelihood of the risk of fire was high, On the question of the availability and suitability of ways to eliminate the risk or reduce the hazard, Mr Neese agreed that it was most relevant that the mining operator itself had identified in its rehabilitation plan that rehabilitation was a way of eliminating fire risk. He also agreed that it was most relevant that the mine owner is committed under its licence to progressive rehabilitation. It's an already existing measure that it must take. It is therefore available. On the question of cost, it was also agreed that it is highly relevant that it is a cost the mine operator must already incur. You will remember the policy document on cost. VWA's policy said, among other things, on the question of cost, that once other factors are established, safety measures should be implemented unless the cost of doing so is so disproportionate to the benefit in terms of reducing the severity of the hazard that it would be clearly unreasonable to justify the expenditure. Now, of course, that is a policy document, and ultimately the meaning of Section 22 is a question of statutory construction. However, Mr Neese agreed that was the right way to interpret the relevance of costs. Considering the issue more generally, looking outside of the strict matrix of Section 20, subsection 2, for the purposes of the Board's deliberations, it is our submission that that statement about cost is an appropriate and clear way of encapsulating the relevant considerations. The mine has resisted any suggestion of faster rehabilitation, as I said before, on what are in our submissions vague grounds without any real support. As a matter of logic, one can well understand that changing the sequence of rehabilitation will have the result of incurring additional costs. But it's noteworthy that, having heard Mr Graham's evidence, GDF has quite precisely quantified rehabilitation costs and no doubt was in a position to quantify incremental costs, but it has not done so. Finally, on the question of costs, you will recall that Mr Lapsley confirmed that the costs of the emergency operation were about $32.5 million. Mr Alan Hall from the Department of Human Services gave evidence that, in short, the financial assistance provided by the government was in the range of $7.35 million. The total calculated cost of the fire is therefore about $40 million, not taking into account the value of volunteer labour. That is a very relevant metric when considering whatever the incremental costs of doing rehabilitation quickly might be, or more quickly, I should say. I want to briefly address the question of the bond, and I should say I'm almost finished. The rehabilitation bond, the facts concerning it are these, in short. It's in the amount of $15 million. It was fixed in 1995. It has not been amended since. It was not amended in 2009 when the area covered by the mining licence was expanded significantly. DSDBI has a current methodology for assessing rehabilitation liability, but it has not used it in this instance. The Minister has a power under Section 79A of the Act to require a mining operator to assess its liability and to have that liability audited by an independent auditor. That has not been done. DSBI has engaged in a review process which it started as late as 2010. It stopped it in 2012 and has started it again in 2013. There's no suggestion about when that might be concluded. Ms White agreed that it was highly likely the bond was inadequate to cover rehabilitation costs to the end of the life of the mine. Mr Graham volunteered a figure of $800,000 to remediate 9 hectares of land. It's accepted that not every hectare will cost the the same because it will be in a different part of the mine and so on. He then disclosed that in fact he thought the costs would be more like $995,000. On the figures raised by GDF in their cross-examination of Ms White, on the area of the mine remaining, if those figures are correct, just applying that to get some sense of the magnitude, it would be a cost of $118 million to finish remediation. Mr Graham said he thought that in his budget the numbers were less than $100 million or 80-something. Clearly, there's a very vast difference between the amount of bond and the amount of remediation costs. In our submission, read properly in its statutory context, which is Part 7 of the Act, the principal purpose of the bond is to shift the risk of uncompleted remediation to the mining operator. It, of course, serves the purpose also of being an incentive, a very powerful economic incentive to complete remediation. In this regard, I won't take time, but I refer to the context being sections 80, 81, 82 and 79A of Part 7 of the Act. Of course, the Minister can recover as a debt any outstanding money if the Minister requires to do the clean-up himself. But that leaves the risk of recovery resting on the Victorian taxpayer. This is a situation in our submission which is wholly unsatisfactory. Mr Graham argued that the purpose of the bond was to quote him some kind of retainer, which implicitly would cause the mine to be incentivised on pain of not getting its bond back. But clearly, it's a much lesser incentive than it would be if it equated to the outstanding cost of remediation. One must ask rhetorically, why would it be that the Minister would not require an assessment under Section 79A of the rehabilitation costs, an audited assessment? And why would it not be that the Minister would require the posting of an additional increased bond? The ball in our submission is very clearly in the court of the Minister in this case. Without an adequate bond, the risk remains with the state of Victoria and ultimately Victorian people. The mining operator is not being required to pay a cost of its operation from which it gains substantial benefit. In conclusion, before I turn briefly to our proposed recommendations, it seems to us that there are some striking facts about the events and the surrounding circumstances of February 2014 fire. There was a known risk of fire that is a natural consequence of mining, and mining so close to the town of Morwell. Unsurprisingly, it eventuated. There is a natural connection between fire risk and rehabilitation. But the regulatory framework within which this is considered tears those two things apart. There is a rehabilitation plan that has no milestones other than those tied to the mining schedule. On this, the mining operator and the regulator have diametrically opposing views about what it means. Those views were not apparent through the cooperative regulatory process. They became apparent during the course of this inquiry. There is an adequate security bond that has not been revisited since 1995. Finally, both regulators have adopted an extremely narrow reading of very important empowering acts and regulations. They have a memorandum of understanding that has not delivered a holistic approach to the risk of fire. In this respect, regulation is not working. There are, however, real opportunities for improvement that start with revisitation of the rehabilitation plan. It should not be business as usual for the coal mining industry in Victoria after what has happened. The people of Victoria, and in particular the people of Morwell, deserve a lot better current system of regulation means that the miner will do as little as possible for as long as it can, and the regulatory system permits that. At the moment, GDF Sewers is being left to balance the costs between itself and the community. It can't really be expected to do that balancing exercise other than in its own commercial interests. That balancing exercise needs not be left to it, because every time the community will come last. By ensuring an appropriate rehabilitation program takes place through good enforcement and a suitable bond, the inquiry has the opportunity to ensure that the legacy of coal mining in this locality is one of good, cheap power rather than one of environmental destruction and community suffering. Can I mention recommendations that we propose? And as I've indicated, we will provide these in writing to the inquiry through council assisting. Firstly, on the question of rehabilitation, we support council assisting's recommendation at paragraph 77 regarding section 40 subsection 3. We also suggest, as part of a multi-pronged approach, that amendment be made to Schedule 15 of the Mineral Resources Sustainable Development Regulations to specifically require that rehabilitation plans include within work plans for a mining licence consideration of the means by which progressive rehabilitation may mitigate fire risk. Thirdly, it should be recommended that both DDSBI and VWA acquire as a priority the expertise necessary to monitor and enforce compliance with measures with respect to measures to mitigate fire risk. On the rehabilitation plan itself, Environment Victoria proposes first that DDSBI, with assistance from external consultants, review the 2009 rehabilitation plan and the proposed 2013 plan with a view to the following. First, identifying areas of the mine in which rehabilitation can feasibly be accelerated for the purposes of fire mitigation. Second, determining whether the rehabilitation schedule should be generally amended, examining the role of legitimate operational constraints such as infrastructure, specifically with a view to fire mitigation. Third, to the extent that, and while the existing schedule remains extant, DDSBI clarify its requirements in relation to those areas that are nominated under the current plan and indicate by what time it requires them to be completed. Preference should clearly be given to commencement sooner than later. In that connection, DDSBI should require time-based milestones for the achievement of the next planned phase of rehabilitation and as revised progressively. Finally, DDSBI should specifically investigate the sources of overburden for the use in rehabilitation. Next, at a minimum, there should be an annual review of progressive rehabilitation targets to ensure that scheduled rehabilitation is both underway and a planning process for future rehabilitation has commenced. There should be an amendment to the Act to require the public reporting of progressive rehabilitation work plan compliance. Environment Victoria also supports Council Assisting's recommendation at paragraph 4.4 of their submissions concerning a full risk assessment of the likelihood and consequences of the risk of fire and the most effective means for fire protection for exposed coal surfaces, including final rehabilitation. The only caveat we make is that we read final rehabilitation in Council's document to include a reference to progressive rehabilitation. Finally, on the rehabilitation bond, we propose two recommendations, and they work in tandem, although they are quite different. First, the inquiry recommends that the Minister exercise the power under Section 79A to require the licensee to conduct an assessment of its liability, and that assessment be audited. Second, that recommendations be made to support a review of the department's methodology and the parameters for assessing the quantum of a rehabilitation bond it will accept under Section 80, specifically concerning this mine, but we accept that may apply more generally to the mines in Victoria. The relationship between these two recommendations is that under Section 79A, the mining company will assess its own costs of rehabilitation. The second step deals with what it is that the department will accept as a rehabilitation bond, because of course there remains the prospect the department or the minister will say, I will accept a bond that is less than the costs. In our submission, an appropriate way of doing this would be to recommend that the Auditor General conducts that review. That can be probably done in two ways. One, that a direct recommendation be made that the Auditor General conduct that review, or second, that DDSBI request a review, and that is a mechanism that is clearly available under the Audit Act. If the Board pleases, those are our submissions, and if there are no further matters, we thank the Board for the opportunity to make submissions. We were wondering whether we might be excused from further appearance at this point, or alternatively at the end of the day. I beg your pardon.
Ms Nichols, thank you very much. That was a very full exposition on rehabilitation. Of course, you have got leave to discuss other matters, and could I just raise this issue about land use planning, where the Environment Victoria's got a view about that, particularly with regard to plantations or other vegetation near the mine?
I just need to get some instructions on that. I can't really assist other than to say that we support Council assisting submissions. I'm sorry that's not particularly helpful to contribute to the answer to the question. But
yes, I see no reason why you should not be excused.
Thank you.
First, let me thank the Board for allowing us to appear today. Thank you very much. My name's Peter Marshall. I'm the National Secretary of the Firefighters Union. We have provided two submissions to the inquiry. One was on the 20th of May, and I apologise, I don't think it was actually dated when we sent it. Then there was a second submission on the 6th of June. May I state firstly that I'm sure there's an agreement one of the greatest assets of Victoria is its firefighting staff, in particular the career and volunteer firefighters. I think that's not in question. What is disappointing, though, is that at the moment their concerns are only being voiced through their union, being the United Firefighters Union. And unfortunately, we've been unable to bring to your attention significant matters that they would like to because of potential adverse consequences, which I'll deal with later on. But if I could I take the Board through our submission in brief and then some recommendations if possible. Effectively, just for the record, and I apologise, I haven't done this before for a long time. United Firefighters Union is a federally registered organisation. We represent approximately 10,000 firefighters in Australia. We have appeared before tribunals, a coronial inquest and Senate inquiries. In particular, we have a very legitimate concern about firefighter contamination. We appeared before the Senate inquiry into the Safety Rehabilitation and Compensation Amendment, Fair Protection for Firefighters Bill in 2011. That was in relation to cancer-related illness that firefighters contract in the course of their employment. That Senate inquiry accumulated in a report from the Australian Senate that actually found that firefighters are more susceptible to certain types of cancers, approximately 12 types of cancers, as a result of continual exposure. It is an unavoidable risk for firefighters, and I think it's important I traverse this ground because they're predominantly a lot of our concerns. It's an unavoidable risk for firefighters for this simple reason, that their uniform must breathe. It provides them protected from radiated heat and from being engulfed in flame. It's the state-of-the-art protection, as we know, as we currently exist globally, and we're actually part of a global alliance that keeps checks on these things. But it also has to release metabolic heat build-up, so the uniform must breathe. So whenever a firefighter is deployed into a combat situation, they're exposed to the toxins in that environment. There is numerous reports now, and there's no debate in the scientific community, that firefighters are more susceptible to cancer as a result of their service to the community. The Senate inquiry found that firefighters forego quantity and quality of life in protecting the community. And that is paraphrasing, but essentially I think that's at the end of their report. Hence, decontamination procedures are very real for us. They're very real because the illness is very real. The Australian Parliament, as a result of that Senate inquiry, adopted legislation. It's called presumption legislation. That recognises that firefighters do have that increased risk, and there's a reverse onus placed on proving that illness on the employer or an insurer as a result of the circumstances for firefighting. For example, previous to that legislation federally, firefighters had to prove which fire, which toxin out of tens of thousands that caused their cancer to be able to make a claim for compensation. It was an impossible task. Hence, they actually implemented that legislation with the reverse onus. It's a rebuttable presumption, so there's checks and balances. I make that point because it's not just about compensation. As part of that Senate inquiry, what came out of it was an awareness that we could do things better, being decontamination. In the old days, when I was a firefighter on shift, you used to sit around in a dirty uniform. You can't do that. We didn't have the knowledge that we do have now. Employers adopted procedures, in particular procedures of decontamination, the quick turnaround of dirty personal protective equipment to ensure that there is limited exposure to those carcinogens so they don't leach into the skins, through the pores of the skins of the firefighters. They're working, they're hot, their pores are open. I've explained how the uniform must breathe, so whatever's in the atmosphere leaches into their skins. So decontamination procedures are very important. Apart from the Senate inquiry in 2011, we appeared before the 1997 Dandenong inquiries, before Coroner Johnston, in relation to the death of a number of citizens in Dandenong fires. And indeed, as a result of our appearance, a number of recommendations were made, and they're included in that coronial inquest report. We also appeared in the Longford explosion as a wider representation for Trades Hall Council. We also appeared at some length in the investigation inquest into the wildfire and deaths of firefighters in Linton in December 1998. As a result of that, a number of our submissions were picked up, in particular the requirement for safety officers. In 2009, we looked at the Board of Reference, and we appeared before a independent Board of Reference to look at standards of fire cover for Victorians. In 2009 also, we appeared before the Royal Commission of Victoria Bushfires. The reason I bring these matters to the Board's attention is that we have a long history of appearing before this type of inquiry. If I could go to our submission. Without going to the legislative framework of the CFA and the MFB, essentially it's about protecting life and property, and I don't need to take the Board to that. I'm sure you're well aware of it. But if I could, without dropping these papers, just briefly go through this submission. Essentially, the chronological events are simply this. On page 10 of our submission, on the 16th of February, it was brought to our attention by our firefighters that we represent that there was a number of significant concerns in relation to them being deployed at the Hazelwood Morwell Yallourn fire. In particular, the length and tour duration of including meal and rest breaks. Fatigue is another known factor that causes firefighter injury, as well as potentially exposure to injury and even worse. Mandatory breathing apparatus wearing is direct, which does not conform with 2-hour turnaround or current BA procedures, 30 minutes per cylinder, and changeover BA to occur in clean environment. We couldn't see how the standard procedures that firefighters were actually had been trained on could be implemented in the circumstances where the duration of the set was not long enough. Not only that, the rehabilitation area was also in a hot zone. Personnel instructed to wear BA and not doing so. Well, in some senses it was impractical, but there were alternatives which weren't brought to the attention of this tribunal, and that is there are long-duration breathing apparatus available. Essentially, they used to be what they call BG 174s, superseded by what they call BG4s. As I said, I'm somewhat embarrassed that firefighters are not able to give this evidence themselves, because they would dearly like to be here today. Rest areas in hostile environments, exposure to unnecessary levels of heat and exposure to carbon monoxide. We note Council Assistant's recommendations to the board, and we appreciate that, the fact that firefighters were unnecessarily exposed. Clean dirty areas are not uniform amongst CFA and MFB, causing unnecessary potential exposure to toxins, both known and unknown. I placed that in the context, the reason I opened up with the 2011 Senate inquiry, it is a known occupational illness, being cancer related for firefighters, an unavoidable risk. The very least that can happen is the procedures be put in place to minimise that exposure through having clean areas, dirty areas. Now that did not occur until very late in the firefight. Alternatively, firefighters, there's evidence in our submission that show that firefighters were actually required to wear dirty PPE, personal protective equipment, for long, protracted periods. In fact, they didn't have replacement PPE. Now, I'm not distinguishing between volunteer career firefighters, it was for all firefighters. And indeed, that is dangerous. It's dangerous in the sense of acute exposure over a long period of time, but more importantly, danger in the sense that it's a known factor recognised by the Australian Parliament. Asking whether monitoring equipment is being used for excessive carbon monoxide levels globally and individually. I mean, that's also contained in our submission, and there's evidence from firefighters on that particular issue. Is the carbon monoxide monitoring equipment collaborated for accuracy? These are a letter to the Chief Fire Officer, an email from the Chief Fire Officer, from myself on behalf of the firefighters, and also to the Fire Service Commissioner, Craig Lapsling. What other testing is being done for toxins in the atmosphere? Asking for tests to mercury in water and surface of the coal and atmosphere and to provide results to the UFU. We're extremely disappointed that we actually had to conduct our own independent testing that later revealed that the water was indeed contaminated and it had high levels of E. coli and some other factors which I'll go to in a moment that indeed were not revealed to the firefighters, but most importantly weren't tested for in the first instance. We have to ask the question why we had to engage independent testing for this to be discovered. The responsibility is on the employer. Indeed, the very least we can do is make sure that known risks to firefighters are discovered at an early stage of the incident. They were not. Working excessive hours, accommodation facilities for firefighters inadequate. At one stage there, they had to change the staging area because it was on the coal face. It was totally engulfed in smoke. So they had to set up the whole command post, whole staging area where firefighters are meant to rehabilitate and shift it away. Now that's simply poor planning and not good enough. And look, I say this as constructive criticism. It was a firefight. It was a very long, dirty, hard job. We acknowledge that. The firefighters went probably beyond what they normally would because we understand it was a major asset, or they understood it was a major asset for the public of Victoria if the power stations had been knocked out. So we do understand that, so it's constructive criticism to make sure it doesn't get repeated. So that's a letter essentially encapsulating some of the issues that we spoke about with the Fire Service Commissioner and the Chief Fire Officers in the early stage. And can I say, unfortunately, there was more conversations and more conversations. And if I could just briefly go over the paragraphs, but the chronological events of our involvement in this fire and representation by our members is contained in our report in our first submission. Clean dirty areas, 3.2.2 of our submission on page 14 is extremely important, and I've explained why, and I appreciate, and I don't mean to be lecturing tribunal. Sorry, but it is something that's very real for us, and indeed we set it out in great lengths. 3.2.3, amenities and further equipment issues on page 15. Mess areas are not enforced as specific PC, personal protective equipment clean areas. Can I say that you don't, in the old days it used to happen, but we know better now. And what they were doing is they were bringing dirty uniforms, the material from their firefighting boots. Sometimes it was the company, sometimes it was people who weren't educated, into an area where they were eating their food and supposed to be rehabilitating. That's against procedures, and it was wrong, and we had to raise those issues on a number of occasions. Exposure testing. We're very concerned that firefighters were not given the AMCOS report in the early stages. In fact, it only came to our attention in March. Now, at the end of the day, there may have been more information, different information, but we haven't received that. And more importantly, the firefighters have a right to know what they were being exposed to. And indeed, the AMCOS report recommended procedures that weren't brought to the firefighters' attention. And we're disappointed in that. Safety equipment on 3.2.5 of page 16 of our submission. Number of firefighters informed us that the company employees were wearing what they call P3 mask, whereas we were being issued with P2 masks to filter out particulates. We requested P3 mask, but they weren't forthcoming. It's probably an internal matter between the fire services and their technical people, but we just raised that issue. Breathing apparatus on 3.2.6 of our submission on page 17. Those procedures simply were not applied. The standard operating procedures were just simply not applied. And whether it was not practical to do so was not an answer, because firefighters have a right to being deployed safely as much as possibly. And indeed, the information that the firefighters were given in relation to wearing breathing apparatus differed at various times, and indeed the evacuation or total exiting of the firefight area, that was indeed different at different times. It also was reported, the last paragraph of page 18 of our submission, that there was not enough breathing apparatus sets and cylinders to protect all the firefighters on the fireground for the duration of their 2-hour or more deployment in the mine. Now, I can't really understand that, because there is large-scale capability of breathing apparatus. I'm not sure what went wrong there, but again, a firefighter should not be deployed without having the proper safety equipment, at least accessible. Even if they weren't wearing it initially, it may be required, because of changed circumstances, that indeed they would have to put on breathing apparatus very quickly to protect their own health and safety, or to provide a rescue for someone. Fatigue is a significant issue, which was highlighted by firefighters down at this particular firefight. Some firefighters were working up to 18 and 22 hours consecutively. That is simply not safe. It's not safe for a number of reasons, as well-meaning as it may be, or alternatively, logistically, the coordination was not there. Essentially, 18 to 22 hours as a firefighter is just simply too long. People become fatigued, they make bad decisions, and indeed someone can get hurt. Additionally, it's that exposure I talked about also, as well as the fact that the uniforms, they actually conduct a fair bit of heat. So wearing a firefighting uniform for 18 to 22 hours is just not good, although we do acknowledge in some cases they were using a lesser hot uniform, being a wildfire uniform. So, there are numerous instances where firefighters worked excessive hours with direct impact on health and safety. Firefighters reported working 12 or 16 hours at Hazelwood mine with little or no breaks during a firefight. Contaminated water. We understand that the water supply was scarce, and it's often that firefighters actually use what we call open water. But there was enough time, and indeed the testing didn't reveal the fact that water was contaminated. And one firefighter sustained a very severe injury as we think, as a result of that. Firefighters were regularly exposed to this water on their face, nose, eyes, mouths, ears, hands, body and legs, often soaking right through their personal protective equipment. Again, the importance of having replacement PPC rather than it sitting around in wet and contaminated uniform. Following a series of safety breaches at Hazelwood incident, the UFU undertook to have its own independent testing. And as we know, the testing was in response to reports a firefighter reported getting a serious infection, septicemia, from a paper cup wells at Hazelwood. The results indicated that the water contained high levels of chloroforms and E. coli, Pseudoaeromonas, if I haven't pronounced that correctly, I apologise, was also detected. This testing was commissioned by the union on the back of other testing that had been done that didn't reveal this contaminant. Now, that's wrong. And we say that no expense should be spared in trying to provide firefighters with a safe environment. That testing should have been done in the early stages, or at least before we actually requested independent testing. Staging areas and divisional command, 3.2.10 on page 20. Second paragraph. Firefighters reported to the UFU that the staging area at one stage was set up close to the mine edge, and divisional command was moved on Saturday night, the 15th of February, due to a wind change, and the entire area being overcome by high CO levels and ash and smoke. Again, this is constructive criticism in hindsight, and we understand it's in hindsight. Firefighters have also reported that due to the staging area being close to the power lines, the staging area radio to the front gate was constantly cracking, and in the end, CFA staff were forced to use their personal and or work mobile to communicate with staff to facilitate the moving of appliances. It is a known fact that the power lines interfere with the radios when it's in close proximity. CFA personnel reported that mine employee staff tried to take away CFA log records as the books movements of people in and out of the mine. We say that as constructive, as it's a management issue that really is the fire service's responsibility to make sure they log the movement of their personnel. There was an issue regarding staffing, which I won't go into because it can be seen as too political, but it's there for the record, and there was an issue regarding staffing and running out of people down at that particular firefight. Emergency roster was implemented that highlights our concerns as being legitimate, and that's at 3.2.11. There was an issue regarding crewing of appliances. Some of these matters have been referred to the Victorian Work Authority for investigation. Most importantly, this one here on 3.2.13 just should not have happened. In the context of previous coronial inquest, in particular Linton, sector commanders need to be trained. You cannot deploy someone to be a sector commander position without having the training. On numerous occasions, there was people deployed who did not have either the training, or alternatively, in some cases, there wasn't any sector commander. Now, that flies in the face of previous recommendations for coronial inquest, but most importantly, standard operating procedures, and again goes to the very health and the safety of the firefighters. I won't go into how that's actually governed, but it's set out on page 22 of our submission, our initial submission. Communication, there was an issue regarding communication. Firefighters' main concern, and I'm talking about 3.2.15 of our submission, second paragraph. Firefighters' main concern was lack of communication from firefighter on the fire ground to divisional or sector commands in regards to firefighter wellbeing and health and safety, Information on how the firefighting was progressing, whether an appliance was in the optimum position to fight the fire. Communication was very much one way from the sector command. There was problems with communication. I think that if you traverse every coronial inquiry, including the Royal Commission, there's always been problems with communication. Mine guides and maps was an issue. In some cases, firefighters were left on their own to find their way, and indeed some got lost. Statements of firefighters. We've actually underpinned what we actually submit to this inquiry by appendixing statements from various firefighters who actually were deployed, but unwilling to be named because of the fear of potential adverse consequences. And I say this with respect as to the inquiry to be able to determine exactly what went wrong or what went right or what was done properly needs to get the information. On 27th of February, the MFB put out an email asking for employees to submit improvements that could have been placed as a result of their deployment to Hazelwood. They also put a further one out, I think it's on the 26th of March. I'll have a look at that date because I have got the date here. And that was from hazmat technicians. And the hazmat technicians were the ones who are trained specialists in relation to the exposure of the community and the firefighters. I know from reading the evidence here that a lot of that information didn't come to this inquiry. And you've all heard about Firefighter Al. Well, Firefighter Al brought it to our attention because he was dismayed the fact that it hadn't been raised here. Now, I don't know if the inquiry has the scope to be able to, for future inquiries, to put in a procedure where the operational firefighters are at the coalface without fear of consequences can bring to the inquiry matters of concern that they experience. I think that is a severe limitation on any inquiry to get to the bottom of what actually happened. And we say that as constructive criticism. I have spoken to numerous firefighters, both MFB and CFA, who have valuable information that they would like to bring to this board's attention, but can't do so because they're fearful of retribution. We made a number of recommendations, and they're set out in our submission on page 24. And essentially, if I just go to some of them, page 25, recommendation 4, that the CFA and MFB must have health and safety HSRs at major fires and incidents. We note in the coronial inquest in the Linton, safety officers were raised. The UFU was actually asked to be part of this firefight. It's not appropriate for us. It's not our role. So they wanted to embed us in the structure. It's just not appropriate. So what we did do, we actually asked for health and safety representatives, coordinators, to be deployed at all times. Now, a lot of problems were averted or rectified because of that deployment of HSRs. They're firefighters who have been trained in health and safety and have qualifications. We think that that should be a standard procedure for large-scale incidents, indeed protracted incidents. And we point out that in 1998, December, into the deaths of firefighters at Linton, 5 firefighters at Linton, that there was a recommendation for a safety officer. And indeed, we embrace that with open arms. We are concerned, and we respect this board as well as council assisting, but we're not quite sure, and we didn't have the resources to be able to afford council to cross-examination. But essentially, we had an email that actually referred to the lack of safety officers being able to be found by the CFA and a request for the MFB to try and find safety officers. We're unsure, and I'll bring you to the tribunal's attention on exactly what that was. I think it was 5.112.10. Yes, it's 5.10.11 of our submission. And it's annexed as attachment 5.1 of 11, sorry. And it says, and it's from the Emergency Command Centre on 4th of March 2014 to all station, all platoons, which means it goes to every fire station, every firefighter. The ICC at Hazelwood require a senior station officer, commander, acting commander to act as safety officers for the nights of the 6th, 7th, 8th and 9th night shifts covered as a block, as the CFA are unable to fill those positions. We say this in the context that there's no contrary information other than Mr Lapsley's evidence before this Commission about safety officers, and I've explained why we were unable to fund, if you like, resource cross-examination. Can I also say that many of the safety issues we have raised, if there were safety officers there at all times, would have been checked by the safety officers. They were not. So we have concerns about that. We say that the CFA and MFB recommendation number 7, that the CFA and MFB enforce decontamination procedures in areas at the incident to prevent ongoing exposure to the firefighters of toxin, including the prevention of wearing of used PPC outside of the fire or incident zone. What we're asking for there is a reinforcement on what is known and what has been determined by the Senate of Australia and the Parliament of Australia based on evidence. And that is, it's just totally unacceptable for this day and age for contaminated PPE to be traversed into clean areas. It is totally unacceptable for firefighters to be left in contaminated PPE and not have replacements. And again, we put that as constructive criticism. We go on to do recommendation number 8, and indeed at the early stages of the firefight, there was very little amenities for rest and recline or rehabilitation, if you like. That evolved over the period to be one of a sophisticated nature, and we acknowledge the fact that it was protracted. However, there was a period of time there, a considerable period of time, where firefighters didn't have a proper rehabilitation area. Number 9, our recommendation number 9 on page 25, MFB CFA must monitor all firefighter staff so excessive hours are not recorded during major fire incidents. Firefighters are good people, as you know, and they want to protect the community. And unfortunately, some of them are their own worst enemies where they'll work excessive hours. So you have to have checks and balances. We are aware where people exceeded enormous hours down there, and that is very dangerous. Because it can result, as well-meaning as it may be, it can result in injury or death. It's a very serious issue. And then I suppose in relation to communication and interoperability, there's issues contained in our submission, our first submission regarding the Royal Commission 2009 final report, recommendations regarding communication, in particular compatibility, interoperability communication systems between the fire agencies. I'm somewhat embarrassed to bring to your attention that essentially the MFB and CFA, after all the inquiries, still have separate systems, and they're not compatible. For a CFA or an MFB firefighter to be able to liaise with each other, they need to have the other's radio capability. And I don't understand whether that's part of artificial parochial barriers, I don't know, but it just simply does not work. And it's not in the interest of the community or the firefighters. Having said that, that's briefly our first submission that I'd like to bring to the Board's attention, and indeed I do so with all respect. Can I say that the 6th of June we put in a further supplementary submission, and that was from Firefighter Al, who is a qualified hazmat technician. I'm not sure the rules of evidence, however, I have corroborated what he said as he has done with his colleagues, and they concur entirely. Again, I raise the issue, and it's probably outside the terms of reference of this Board, but there needs to be a procedure where firefighters can come forward without fear to be able to highlight problems if they exist. It's not in the public interest that you have an agency that could have been found to be adverse. You could have made an adverse finding against either fire service, as I understand it. It's not appropriate that they collate the information and then only disseminate to this inquiry what information they want to come before you. That is not an open inquiry, and I say that with respect. It's a serious allegation, it's one we stand behind, and it's one that's been asked to be put to us, for us to put to you by our members, because there are a number of people that would love to give evidence. Qualified hazmat technicians that were deployed into the community, that were deployed into the firefight, that are unable to do so because of the fear of retribution. Now, that's wrong. Firefighter Al, as I said, bravely has actually put his statement in, but he wouldn't go as far as, despite us asking for an immunity and the government solicitor giving that to us, not 4 days after, there was an email put out by the employer, Firefighter Al, saying that if you give you a few information, you're potentially in breach of your contract of employment, and you could lose your job, or words to that effect. We've supplied you with a copy of that email. So despite those assurances, not 4 days afterwards, we get an intimidating email that actually suppresses any proper inquiry from the people at the coalface as to what happened. That's wrong. Having said that, respectfully, there are our submissions, and we make a number of recommendations. And as I said, I'm not sure if we've actually gone outside your terms of reference, but we believe they're matters of importance that should be brought to the inquiry's intention, and we do so on behalf of firefighters. I should have said that we represent, out of the 10,000 here in Victoria, we have a 98% membership amongst the workforce. So we are representative of the people who are actually at that firefight. And for the background, I have also been an operational firefighter, although I have been at the union for some time now. David, have I forgotten anything? Did you want to say anything about the information? The firefighter, hazmat guys wanting to be able to talk to the public? Oh, yes. Develop protocols. Yes. Firefighter Al and his colleagues are are somewhat suffering some stress-related stress because of not being able to communicate. They were actually, if you have a look at his statement, they were ordered not to tell the public that the levels were actually changed from 30 to 70, and indeed they had been exceeded, even though they were there amongst the members of the public being asked. That is an excruciating position for a firefighter he's not interested in the politics or the rights or wrong, he's just interested in what he's trained to do, and that is protecting life and property. And Firefighter eloquently puts that in his statement, but it also comes from his colleagues. So we're hoping that there is a change of attitude from the agencies, and we understand that you need to ensure that you don't instill panic in the community, but this was not reckless information. This was vital information that should have been communicated, but wasn't. And again, emphasise that it hasn't been brought to this inquiry attention by either fire service because essentially they gathered the information and they actually provided you what they wanted to provide you, even though I know Firefighter Al and his colleagues did put the information to the agency. So that's a concern.
That recommendation should be broad enough to encompass.
Yes. Council Assisting's recommendation number 12A, it says the provision of training in crisis communication that addresses the human relations and effective dimensions, as well as the provision of simple and meaningful information. We embrace that. I think that goes to the heart of it, but we say it should be broader. Again, I'm not here to score points, but I am here to send their message. And they had vital information they would like this tribunal, to have, but they were unable to do so. Is there anything else? Anyway, I respectfully thank you for your time, and as I said, we say to submit this with all respect, and we are submitting what our members wanted you to hear that they could not say. Thank you. It's one thing for sure, there's a lot of paperwork.
Tribunal pleases. My client's been allocated 2 hours. I'm in the tribunal's hands. There are some themes I could open up this afternoon using, say, 15 or 20 minutes. And then, if possible, I'd prefer to resume in the morning, by which time I anticipate I'll have written submissions that I can supply as well. Or I could hold it all over till tomorrow. But if the tribunal's willing to sit on, I could open up those themes. Tribunal pleases. There are 5 themes I'd like to touch on this afternoon and then descend to a more detailed analysis of the evidence and response to the submissions that you've heard thus far when we go into that in more detail tomorrow. The 5 themes I want to open up this afternoon are as follows. First, the use to be made of evidence. Second, a topic that I call in a shorthand way the good old days. Third, the question of shifting goalposts during this inquiry in relation to the applicable occ health and safety standard. Fourth, the distinction between rehabilitation and fire risk management. And fifth, the approach to lessons learned. Now, there are many more topics and there are many more subtopics, and I'll expand on all of those tomorrow. But for the purposes of this afternoon, it seems in light of the submissions that have been made so far and some of the key themes that have emerged during the 3 weeks of hearing, that it's worth elucidating these 5 themes. The first I mentioned is the use to be made of evidence. In the submissions that have been presented to you so far, a number of observations have been made about evidence that you've heard over the last 3 weeks. But it's the submission of GDS Sewers that before this tribunal moves from hearing the evidence to finding that evidence finding life as either a finding of fact, a criticism, an adverse finding or a recommendation, that a number of questions need to be asked which are addressed to causal links. So you've heard a huge amount of evidence, but before any passing observation or remark about particular items of evidence is crystallised into a finding or a criticism, we make the following submissions about the approach to that task. It's relevant to ask whether a particular item of evidence is capable of or would have been capable of changing in any material manner what was done or what was not done during the firefight.
In other words, does any particular item of evidence demonstrate that it possessed the capacity to alter the course of this fire? I'm going to give you an example. There was a deal of evidence about the question whether or not anyone at the mine rang 000 and by those means alerted the CFA to the fact that fire had begun spotting into the mine. Even at this stage, after 3 weeks of evidence, the materials that the inquiry has before it are not in the form of a comprehensive minute-by-minute chronology with respect to that single item of fact. There is some material, and as late as Friday, more material was coming in the form of logs produced through VGSO. One could devote days, if not weeks, to trying to analyse in minute detail that particular item of evidence. But in circumstances where there is other evidence, which demonstrates that there is no question that the CFA knew that fire had spotted into the mine by 2:30, and I refer here to the evidence of Commissioner Lapsley, who referred in his evidence to reports and minutes that are available that demonstrate that through the hierarchy of the CFA that knowledge had been obtained by 2:30, and other evidence which demonstrates that the CFA had assets that were putting the fire out by 2:45. I'm referring here to the evidence of aerial bombing of the fire. In those circumstances, one has to ask, does it matter whether or not there is a particular item of evidence that demonstrates the precise minute at which any 000 call was first made by mine staff or others in the community, specifically reporting the spotting of this bushfire into the mine? And further, one has to ask what difference could it have made if it could now be shown positively that a 000 call was made at a particular time. Because counsel assisting, for example, do not point to any particular thing that it is said that the CFA would have done differently had they received a 000 call at a particular time. Commissioner Lapsley has certainly never suggested that that is the case. Counsel assisting also does not point to anything that it is said GDF Sewers would have done differently if one of its staff had called 000. And further, there's no evidence, and there's nothing that's been put to any witness, that suggests that any of those hypothetical things, had they been done, would have altered the course of this fire or the extreme efforts applied to putting it out. To turn it round the other way, if one assumed that there was firm evidence of a particular call being made through to 000 at a particular time, could it also be said that the response of the CFA would be, thank you for bringing that to our attention, we have ample resources which we will now deploy post-haste to the mine? No, because the other body of evidence reveals that the CFA was stretched and that it was acting according to its priorities in terms of deployment of resources. Would placing such a call have increased the appropriate sense of urgency or the efforts being made at the mine? No. There's no evidence that any witness would have acted differently simply because they had also dialed 000. Would placing such a 000 call have changed the reality about what now appears to be significant deficiencies in the redundancy of power supply through to the mine? No. So in those circumstances, it can be seen that that item of evidence, while it attracted interest and appropriate exploration, at the end of the day, shouldn't be capable of sustaining any negative observation about a failure to put that call or place that call. That's just one example, and obviously in developing the subtopics, I'll draw the Tribunal's attention to others of a similar ilk. The next theme I identified is one called the good old days. Now, what I want to say about that is a tension which emerged in the evidence during the running of the inquiry. On the one hand, a number of submissions and a good deal of evidence from community witnesses in particular harked back to the days of pre-privatisation and lauded the standards applied by the SECV. And the evidence is, of course, that the way that the fire code or the policy has developed in the valley is that there was a 1984 code adopted by the SECV and used across the 3 mines in the valley. It was modified to a degree by 1994, but still applied in the hands of Generation Victoria at this mine, and then adopted almost without change in the 2013 document, which is in use as at today by GDF sewers. It's certainly ironic then that given there was a great deal of evidence and submissions of that ilk, namely that things should have stayed the way that they were in 1994, it's ironic, and there is that tension I referred to, that in the latter part of the evidence, GDF sewers has been criticised for adhering to the tenets of the 1994 policy. By way of example, it was elicited from Commissioner Lapsley that he found it amazing that the 1994 policy was still applied. When Mr Graham was being cross-examined by counsel assisting, it was put to him a number of times that the 1994 code was prepared many years ago in a different world. He was pressed as to whether or not the mine should develop a document suitable for the second decade of the 21st century. In that way, it can be seen that there was a shift from a desire to hark back to the so-called good old days to a call for that very policy or those standards to be modified in light of current realities. It's interesting too that a number of the submissions and evidence from community witnesses as well as Mr Incoll tended to assume that the SECV standard was of a certain type or produced a certain result, and often when facts were brought to witnesses' attention it had to be conceded that that was not necessarily the case, and it was also often assumed that that was the counsel of perfection or the standard that should be adhered to, when in fact there may have been misinformation about what the standard involved. It's submitted that that background is important when we then come to look at some of the subtopics that I'll develop further tomorrow. The third question that I've identified is that of the shifting goalposts in relation to our health and safety standards. As the evidence developed in these proceedings, Professor Cliff's report, when it became available, expressed his opinion that there had been a deficit in the approach by GDF sewers to the question of safety assessments as required by Regulation 5.3.23. Now, by the end of Professor Cliff's evidence, it became clear that he had retracted that opinion by reason of two important matters being brought to his attention, which he'd given further and appropriate consideration. The first matter brought to his attention was the distinction between mining hazards and major mining hazards under the Victorian regime, when compared with other regimes with which he was more familiar and on which he'd been focusing. Secondly, there were a number of additional materials brought to his attention that he gave additional consideration to, which caused him to retract that view. Now we find today that the focus has shifted from Regulation 5.3.23 and the notion of safety assessments that hang off major mining hazards to a suggestion that there is a deficit in the mine's approach to two different regulations, 5.3.7 and 5.3.9. Now, while some of the elements of Regulation 5.3.7, directed to risk assessments, were traversed with witnesses, including Professor Cliff and others, the requirements of Regulation 5.3.9 have not squarely been put to any witness, were not the subject of Professor Cliff's report, and have not been engaged in the same manner as in which the first line of attack pursuant to the safety assessment regime were. The evidence in relation to that is something that I'll develop in more detail tomorrow, but it should be said at the outset that the findings urged by counsel assisting with respect to these regs, 5.3.7 and 5.3.9, are rejected on the basis they are not consistent with a full reading of the evidence, and that certain elements of them were not put in terms to the relevant witnesses, so there couldn't be a safe foundation to draw the conclusions that are urged upon the tribunal. The fourth theme that I wanted to open up this afternoon is the difference between rehabilitation and fire risk management. It's submitted that there is a significant difference between the following three concepts about which you've heard a deal of evidence. Some witnesses used the terminology in different ways, but at the end of the body of evidence it appears that there were three concepts upon which witnesses touched. The first is the notion of progressive rehabilitation undertaken during the life of an applicable work plan. The second concept is that of final or end of mine life rehabilitation. Now, the first two elements are obviously governed by and creatures of the regulatory regime, conditions of mining licences, and the content of work plans. But the third notion, which doesn't have a fixed, and in our submission, a term of art meaning, the third notion that came to be spoken of was so-called temporary rehabilitation. Mr. Faithful in his evidence said he hadn't really heard that term before, and it wasn't a term that he used in his work. It may be a handy label, but we submit it has significant limitations, because it turned out what it really meant, or what it really describes as a catch-all, is a collection of ideas that some people in the community and Mr. Incol and Professor Cliff came up with. There were different variations on them. Each of them, in one way or another, was a suggestion that an application of a clay, body of clay or earth, or clay mixed with cement, or clay mixed with ash, might be in some way applied to the exposed coal in the worked out batters. Those who put up these suggestions tended to make them in very brief form, over one or two lines in submissions or witness statements, and when pressed about them, sometimes were non-committal about whether they were suggesting it be applied to slopes as they now stand, almost vertical, or to slopes that were laid back a little or laid back a lot. In short, there was very little detail propounded by those who advocate these fixes, and what was notable about each one of them was the following. Not one was put before this tribunal as having already been the subject of any risk assessment. Not one was put before this tribunal as ever having been the subject of a practical application. The closest we got was a suggestion by Professor Cliff that he was aware of a coating being put over some exposed coal and some stocks of coal in an underground mine. In terms of the way he gave his evidence, it appeared clear he was talking about lying on the ground, not at a near vertical surface or a steep incline. Those who were pressed in relation to these sorts of topics, including Ms. White, including Mr. Faithful, and including Mr. Incol and Professor Cliff, all agreed in the final analysis that these were ideas that might be able to be considered, but that on any view would themselves have to be the subject of a detailed risk assessment of two kinds. Firstly, the doing of the work. Would it expose those doing the work to risks in carrying it out? But secondly, and more fundamentally, would it itself create another suite of problems? A number of the problems were highlighted for the inquiry's attention. Some related to batter stability, a very significant matter that Ms. White spoke of at length, as did Mr. Faithful. Others referred to concerns they had about whether, for example, applying an impervious surface would reduce the current capacity of those experienced with these mines to monitor any shifting in the surface of the worked out batters, or to see whether or not any hot spots are on the move. Others expressed concern that it would have an impact upon the horizontal bores, and that questions were raised about how they would continue to perform their vital drainage function. Each of these ideas may well have been worth raising, but each of the concerns and difficulties raised by others in response need to be given serious consideration. So we land at the end of the day with a number of suggestions, born of good intentions no doubt, but none of which have been subjected to the appropriate rigorous risk assessment process that would need to be conducted, it's clear, both using one's DSDBI hat, what does this do to the mine, and using one's WorkSafe hat, what other risks does this present to those applying this mode of fire risk mitigation and to those who then live with it and the other suite of problems it might deliver. The final theme I wanted to open up this afternoon is the question of lessons learned and the approach to lessons learned. It's submitted that GDF Sewers was the only participant to attend the inquiry and propose a significant suite of recommendations, pursuant to which it had already undertaken to initiate change and spend its own money, to put it frankly. Many times, the inquiry heard evidence from bureaucrats who were prepared to go away and start considering things, have discussions with other people, set up a committee, write a list, advocate change, think about it, talk about it. Very little doing of it. It was Mr. Graham, the asset manager, who came here and said, and he stood alone in this regard, I have the authority to make these changes. I have consulted those below me and who sit with me in the management team. I have consulted those with the expertise, the electrical engineers, those who tell me they know about rehabilitation. I have formed a view about what can be done. I have formed a view about what should be done. And I'll quote what Mr. Graham said at transcript page 2234, irrespective of whether the tribunal recommended them, and he was speaking about the text in his chart marked in red, we think they add value and we would wish to implement them. And it was Mr. Graham who was forthright about the lessons he'd learned from the fire and the reason that he didn't want them to be repeated. As he said, I'm not going anywhere. I'm an Australian citizen now. I'm retiring here and I'm going to be in the community. Certainly I don't want to be in this position again. I don't want the community to be in this position again. And we say his evidence was of a different nature than that which had been put before the inquiry by others, as I say, who, while they evinced a preparedness to consider legislative change, regulatory change, systemic change, much of it sounded as if it was a long way off in the future, and much of it sounded as if it rested upon others making the same commitment, in particular where gaps or possible gaps were identified as between the regulators. But it was Mr. Graham, as I say, who stood alone, who said, I have seen at least these problems. He was frank in acknowledging that the tribunal may well recommend many more different or additional matters, but he was willing to say what the mine was prepared to do, was able to do, and will do. Now, the tribunal pleases, there are a number of matters that emerged today that I would like the opportunity to address tomorrow, and we think we'll be able to do that quite efficiently because we're in the process of having written submissions finalised that will do that. If we can tailor them a little more to some of the recommendations that have been made, I anticipate I can then simply use the balance of the time allocated to me tomorrow. And of course, I'm in the tribunal's hands, but
I think the difficulty is just making sure that we do finalise in time. If you say that there's material going to be in writing, obviously that will be of assistance to you and to us. It may be a 9:30 start.
I was just going to say that
may be the better way, on the basis that if you've still got of the order of an hour and a half, and
looks like Mr. Wilson's
Mr.
not
Wilson,
here. He must have
Mr.
nothing,
Burns,
so
in his absence, has got approximately 2 hours. That means that we have a reasonable prospect of going till 1 o'clock-ish, and if we don't have to go long beyond that, there's still this matter that has been raised by Councillor Sisting, that if some matter takes either by surprise, there's a capacity to put in appropriate written submissions that deal with odd matters, but hopefully not extensively.
Yes.
Does that seem the appropriate course to finish now, but to resume at 9:30 in the morning?
Certainly.
Yes, we'll do that.
All stand.